Hello. So this week, in my understanding and managing diversity class, there were a few things that they would like to discuss as far as court cases and TV shows and commercials. So I just wanted to go ahead and give you the background story of the case that I'll be discussing before I get into my own opinions. In 1990, this university published a job opening regarding a vacancy in the sociology department. The announcement for the replacement emphasized a need for proficiency in social psychology and formal organizations, with a stipulated salary range between $28,000 and $34,000, depending upon experience and qualifications, of course. The university hiring guidelines require departments to conduct more than one interview. However, this procedure may be waived depending on the circumstances. Although Farmer was one of the three finalists chosen by the committee, the university claimed they followed procedural protocol by obtaining a waiver to only interview Johnson Makoba. He was a black African male immigrant. The department chair stated that the panel ranked Makoba first among the three finalists. Because of a perceived shortage of black PhD candidates, coupled with Makoba's strong academic achievements, the panel sought approval to initially offer Makoba $35,000 with an increase to $40,000 upon completion of his PhD. This initial offer exceeded the advertised salary of $28,000 to $34,000. Even though Makoba had not accepted any other offers from universities, this specific university justified its premium offer as a method of preventing a bidding war between two prestigious universities who were interested in interviewing him. This strategy, according to the university, was designed to stop other institutions from hiring him. Farmer claimed that she was more qualified for the position initially offered to Makoba. However, both candidates revealed comparable strengths with respect to their educational backgrounds, publishing, areas of specialization, and teaching experience. The search committee concluded that despite some inequalities, their strengths and weaknesses complemented each other. Hence, as a result of the additional position created by the minority bonus policy, the department that hired Farmer 1 year later. Although the university started Makoba at $35,000 with a $5,000 increase upon completion of his dissertation, Farmer was offered a starting pay of only $31,000 and then only a $2,000 raise after completion of her dissertation. According to the Dean of College of Arts and Science, this was slightly above the mean for new hires in the social sciences at that time. Starting with the initial pay differential of $7,000 upon completion of their dissertations, the pay gap have since widened to $10,000, almost $11,000 because of Makoba's additional year of employment and differences in merit increases granted to Makoba and Farmer. On January 13, 1933, Farmer filed a grievance claiming 4 causes of action. She first appealed that the university dishonored the Equal Pay Act by paying her insufficient wages for equal work relative to a male employee of similar credentials. Her second cause of action alleged race and gender violations under Title VII of the Civil Rights Act as amended in 1991. Farmer's third cause of action alleged that the university breached its employment contract with her by failing to abide by its broadcasted policies defining the terms and conditions of employment. Her fourth and final cause of action alleged to a breach of the implied promise of good faith and fair dealing. The district court also rejected this instruction. The jury returned a verdict in Farmer's favor for her first 3 causes of action, awarding her $40,000 in damages. The university timely filed a motion for a judgment notwithstanding the verdict, or in the alternative for a new trial. The district court denied the motion, prompting the university to appeal. This was then taken to Nevada Supreme Court. Farmer maintains that the university has not demonstrated that Makoba's race was job-related for the position in question and consistent with business necessities. Farmer also asserts that the university's unwritten minority bonus policy contravenes its published affirmative action plan. Finally, Farmer alleges that all race-based affirmative action plans are prescribed under Title VII of the Civil Rights Act as amended in 1991. Therefore, the university discriminated against her as a female and protected under the Title VII. So, with this background information being stated, I will now proceed with my opinion. Initially, I do feel like the courts favored Farmer, and they also wanted to use this case, I think, as an example because it was one of the first big ones. When I think this case went wrong is when the Nevada Supreme Court accepted an appeal from the university. I think one of the biggest and hardest issues in this case was having to prove that Makoba was hired because he was a male, because that's what Farmer stated in a lot of her statements, it was just because he was male. So it's a little hard to prove that in the court of law. Another controversial case, also having to do with diversity issues and things of that nature, would have to be the one with the Watchmark Commentel Corporation, which was also known as Valiant Corporation, regarding the outsourcing of jobs. After the name change, they finally changed their name to IBM, and that's what they are well known for today. These jobs were outsourced to India. However, the new employees were offered training in the United States for roughly 2 to 4 weeks, depending on the job. And then unfortunately, 60 of the employees were terminated immediately when this came into effect. Some were also asked to stay for up to 4 weeks to train the new employees. The information technology jobs in the United States have gone from high-paying, high-level jobs to very low-paying laborious jobs, depending on what country they are outsourced to. I believe this is because a lot of the jobs are outsourced and companies are able to pay much less for more hours of work. At first, offshore jobs were used for low-skilled manufacturing jobs for much cheaper than here. It helped with increased productivity and lower prices paid for the consumer. It went from making items only to very well-paying jobs such as computer work now overseas. As much as some Americans don't like to believe this, offshoring jobs isn't going anywhere. But if anything, I think it's going to get worse before it gets better. Workplace discrimination and diversity laws is different in every country, but our neighbors are different than we are as well. Canada has better diversity legislation, I think, than the United States. Not by much, but I do think it is better. In the United States, the diversity rules are different per employer. However, in Canada, the government determines a lot of the diversity laws. And then in Canada, they have a lot more respect for their government than I feel that we do in the United States. Even though the government is powerful there, it's not as powerful as the government here in the United States. I've read in some articles that consequences are given out to employers that do not follow the diversity and discrimination laws that are put into place. And then in the United States, it's different because there's the Equal Opportunity Act. However, every employer has their own rules and regulations as far as hiring processes, unless they are federal jobs. Then that is a little different. I can also only go off personal experiences. I've been to Canada many, many times. I do have family out there. And it just seems different out there. I feel like people are still very divided here in the United States. And I'm also in the Bay Area, which is a very diverse area, and I still think that there's just a lot of secluded people. However, when I go there, I feel like everyone's mixed with everyone, so maybe that has something to do with it. I just feel like every time I go into a business, I see all different races and cultural backgrounds, and it's just very, very different from here, where it's like if you walk into, Boot Barn over here, you're not really going to see African American people working. You're not really going to see Asian descent working there. It's mostly going to be white people, versus if you saw that in Canada, you have all sorts of people. So it's just different from what I've seen. The last part of this assignment was to watch 2 hours of primetime television and witness what commercials were played. I chose to watch 2 episodes of Joe Kenda, the Homicide Hunter, because it's like my favorite show. This show is about a detective who has never not known who a killer was for any of his investigations. It's based off 2 stories, but it has all the reenactments. I think this program targets anyone who's interested in murder mysteries. I think this show captivates everyone because the killers are of all different ages and cultural backgrounds and races and disabled, everything. The same goes for the victims. They're not only young people getting killed, but seniors as well. I think this program does a great job not showing any bias regarding race and social statuses. I think this program lets everyone know to watch the surroundings no matter where you live, because a lot of these murders are in affluent, rich neighborhoods. No one is safe. I think the commercials target people from about 25 to 60 years old. I say this because it talks about the latest car and truck and out now, and which are more intriguing, I think, to the younger person. Then it also has a bunch of medication commercials for joint pain, depression, and migraines. I don't really believe the commercials that I witnessed stereotyped anyone. I didn't send, and I don't think it sent any cultural messages. I think these were all about health and new toys, I guess, to add to your home. I think the show was much more controversial than the commercials. If you have not watched The Homicide Hunter, I suggest you do, because it's amazing. It can be quite creepy, but it's definitely very entertaining with fun twists in most of the stories. Thanks.